Welcome to Aspen Leading Edge. I'm Patty Roberts, Dean of St. Mary's University School of Law, and I have three of Aspen's authors with me today, three distinguished scholars, leaders in constitutional law and other areas whom we'll talk to, Professor Geoffrey Stone, Professor Leah Litman, and Professor Aziz Huq. Welcome. Thank you so much for being a guest on Aspen Leading Edge.
Thanks for having us.
What Jeff said.
Thanks.
All right. Well, thanks. Well, first, the reason that I have all of you on the podcast today together is because I wanted us to talk a little bit about your upcoming book. But before we mention Constitutional Law's 9th edition, maybe you can tell our listeners a little bit about each of you. Professor Stone, I know that you were previously Dean of the Law School and Provost of the University of Chicago, but tell the listeners a little bit about what you're doing now.
Well, in addition to getting ready for the publication of the 9th edition of the Con Law book, which we first put together in 1983, if I remember correctly, I'm writing a number of books with Lee Bollinger, the president of Columbia University. We have one coming out in the beginning of February on affirmative action, and we have one coming out, which is a collection of essays, probably in the fall, on abortion. And I also have a book coming out through Daedalus, the American Academy of Arts and Sciences, on the future of free speech. So pretty busy.
You are pretty busy. I don't know how you have time to be the Edward H. Levy Distinguished Service Professor of Law at the University of Chicago, but you must be making time to do that too. Okay, and Professor Litman, you are a professor of law as well, who teaches on constitutional law, federal courts, and federal sentencing. And tell us, in addition to the book, what you've been working on most recently.
So I received tenure at the University of Michigan last year, so went through that tenure process. And
Congratulations.
Since then have been celebrating. On top of that, I co-host a podcast about the Supreme Court, strict scrutiny. I'm also working on some law review articles. I am trying to write a book proposal for my very first book about the Supreme Court's role in our constitutional democracy. And I also litigate cases as well. I argued a case this past spring in the Michigan Supreme Court, which ultimately concluded that our state's civil rights statutes prohibit discrimination on the basis of sexual orientation.
So another slacker, apparently.
I mean, I'm not writing 3 books, but
well, you have a lot going on, so that's really exciting. And strict scrutiny, I asked you before we started, that's been going for years now. When did you start that?
Summer 2019, so 3.5 years.
And really the go-to podcast. I'm a little bit nervous doing a podcast with such an experienced podcaster. And I know you also have the Take Care blog and Women Also Know Law. And later on, I'd like to talk a little bit about that, time permitting. Professor Huq, you are also at the University of Chicago Law School, and you are a scholar of U.S. and comparative constitutional law. You work on pretty pertinent topics to everyday life these days, democratic backsliding and regulating artificial intelligence. Can you tell us a little bit else about what you do in addition to writing the Con Law book with your colleagues?
Sure. So I teach con law at the University of Chicago, where I use and have used what I would call the Stone-Seidman book for now more than a decade, and have always really enjoyed it, and was delighted when Jeff reached out to me to ask for my participation in it. My academic work these days is, as you said, split between work on what I would call democracy and the rule of law. So in that field, I have a forthcoming book on the history of the idea of the rule of law, and an edited volume that I'm working on with my frequent collaborator, Tom Ginsberg, on the way in which constitutions around the world regulate parties and elections. And then I have a second strand of work on the way in which technological developments and in particular, the adoption of machine learning tools by the state, and in particular, its coercive agencies like the police or immigration enforcement, how that's going to change the way we conceptualize constitutional rights. And that's the subject of a number of law review articles, but it will also be a book from University of Chicago Press sometime in the next year or so.
Well, that's very exciting. It's certainly impactful in everything we do each day. I heard recently about some surveillance equipment that's being put in our own state for everyone who drives by. It's going to do all sorts of things on the highways that's going to enable the government to know who's driving by, what they're driving in, that kind of thing. It's really the Wild West when it comes to artificial intelligence and privacy. Okay, well, let's talk about the book. I cannot even imagine being the author. Well, I can't imagine being the author of a common law textbook. Let's be serious about that. But even if I were to be one who was updating it in 2023, what a daunting task, given the kinds of decisions that we're seeing rock the world of common law recently. So tell me a little bit about that process. Two of you are new to the book, is that right? Professor Litman, Professor Huq, yes. And so how did you and your fellow authors all decide what to put in, what to focus on, and make sure that this was reflective of the evolving rule of constitutional law?
Aziz, do you want to take that?
I think this is a difficult time to be editing a con law book because we're in a moment of transition and it's not clear how far the transition will go. So I think in our approaching the new edition, what we're very conscious of is both the need to identify the size of the change that the law is undergoing, particularly, for example, in the abortion, the Second Amendment, and the First Amendment spheres, without being too certain or without being closed about where things will go in the future. So, at least to my mind, the new edition is coming out in the midst of a moment of transition on the core, driven by changes in personnel of the sort that we've not seen in several decades, and therefore has to navigate a degree of uncertainty that I think, and Jeff will say if this is a correct presumption, hasn't always been the case in earlier editions.
Well, it's interesting because when we first began this book, there was a predecessor book published by Brown, Freud, Sutherland, and Howe, which was a leading common law case book for the preceding 50 years, which I had used when I was a student. And the publisher came to me and said, "Would you want to just take it over and amend it going forward to the next edition?" And I looked at it again more carefully, and I said, "Times have changed." And that book was really written for the 1930s and 40s. And even though it has the stuff in there for the years and decades in between, one needs to take a new look at this all because of changes in the court, changes in constitutional law. And I think we're at a moment where we're likely to be approaching a similar need for reexamination. I don't think we're there yet with this new edition because it's still the beginning of a period of probable transition. But I do think we're headed into a very interesting and from my standpoint, problematic era of constitutional law. And that's going to be a challenge as we move forward with the casebook.
If I could just add, so I actually had the good fortune of learning constitutional law from what I would also call the Stone-Steinman casebook. So I was delighted, to be invited to join the book recently. But I think part of what makes this book well suited to the moment is particularly in the initial chapters, but really throughout some of the more later chapters in areas where the law is changing. It invites readers and professors to kind of think about first order questions about what is the Constitution? What do we mean when we talk about constitutional law and constitutional politics? How should the Constitution, whether we're talking about, the big C Constitution, the document, or the little c Constitution, our norms undergirding our, system of government, how should that be interpreted? How should we be thinking about that? And, what is the role of judges in a constitutional democracy? And I think in a moment of transition when maybe a lot of things, or at least more things, might be up for grabs in the near or far future, it's important to be thinking about those issues early on, in a course on constitutional law and really throughout the semester. And I think the book does that really well, in addition to kind of providing a more complicated picture, of the arguments within the doctrine or based on history or within any particular methodology.
I guess I'm delighted to hear that, because when we first created the book back in the early 80s, that's exactly what we sought to achieve, which was a book that was not simply informing students of what constitutional law is, like black letter law, but rather challenging them and engaging in complicated and difficult questions. And our view is that's exactly what legal education should be about. And that's exactly the mission that we set to ourselves in the book. And I'm delighted to hear that Leah, having recently learned something from the book, describes it exactly that way.
Well, that's exciting because you will be training those people who will help shape these changes that we're going to see in the coming decades. So I'm glad that you're getting them to think beyond what the black letter law is right now. Does it engage in some significant policy discussions regarding the Dobbs decision, for instance? And I should note for our listeners that Professor Litman is wearing a shirt 1973 as her tribute to the Roe versus Wade decision. But does it explore what is likely to happen or what might happen after the Dobbs decision? And then how also have you expanded on the religious clauses information in the book?
So I'm happy to talk a little bit about Dobbs.
Sure.
So I think one thing that the section and chapter tries to do with respect to Dobbs is complicate or invite questions from the reader about some of the narratives and theories underlying the decision in Dobbs. So, for example, the claim by Justice Alito in a footnote that was previously made by Justice Thomas in a concurring opinion that one reason why the court should question Roe versus Wade is because, abortion in the United States right now, Black women and women of color, are more likely to choose to have an abortion than other people. And so that narrative for why the court overruled Roe is kind of expressly brought to the fore by the casebook, together with some scholarly and critical commentary about why that might be and some of the equivalencies that line of argument is drawing. Another through line that the book kind of identifies is whether the Dobbs majority is right when they say our reasoning really is just about the right to an abortion, rather than, as Justice Thomas notes in the concurrence, it is instead about the court's broader right to privacy cases like marriage equality or consensual sexual intimacy between adults or contraception. So I think the book, again, it acknowledges we are in a moment of transition where much remains unclear, but it still invites students to kind of develop the critical muscle of asking, do the court's reasons line up with their declarations about what they are doing? Do I think their reasoning is going to stop at abortion, or is it going to extend to other rights? if I don't think the court is going to take that next step, why might that be? So it invites people to think about possible implications, both from the perspective of internal doctrine, as well as we were just kind of talking about, some of the other sources of constitutional law and constitutional politics.
Excellent. And this book is intended, I noticed from the description, to be a 2-semester course. So really giving students an opportunity to dive deep into that critical analysis that you're talking about. But what about a professor who wants to use this in a 1-semester common law course? Is it equally effective? Can it be equally effective in that instance?
I think that the book was designed to be used in multiple courses. To try to teach this entire book in 1 semester, I think would be next to impossible. Would be for me anyway. And so our assumption is that there are several subcomponents based on the subject matters that individuals can focus on, professors can focus on, whether it's First Amendment, freedom of speech and religion, or whether it's on equal protection due process, or whether it's on structural constitutional law, or can pick and choose as they see fit. But I think it would be pretty difficult to teach a common law course across the board for the whole book in 1 semester. I've never attempted to do that.
And as far as the religion clauses go, how has that approach in the book changed? What sorts of changes have you seen reflected in the law that you've included in this new edition?
I can speak to that. The religion clauses are I think, an example of how the book's historic strengths, or the book's the religion clauses are an example of how the way that the book interleaves historical materials, information about the social and political context in which the court reaches decisions, and evolving and shifting case law come together in ways that really, I think, help both professors teach students how to find their way in the complex context of constitutional jurisprudence, and help students see how changes in the law can be related to and understood in contrast with what comes before, particularly in the context of the Establishment Clause, and perhaps soon in the context of the Free Exercise Clause. The court is taking quite sharp turns. There are ways in which those turns are historically utterly unprecedented. And thinking about the ways that the court has understood, particularly the way in which the exercise of some religiously motivated behavior on the part of one person influences or limits the choices or freedoms of another person, and how it's thought about that question historically, I think provides a lens for students and professors who are grappling with what's happening today in the First Amendment case law. So it's a context in which the historical and richly contextual approach that the book generally takes, I think, provides an anchor for thinking about and for teaching on the changes in the law that we're seeing now.
Well, it sounds like that this will have a great deal of staying power, and already has as a text in constitutional law, because of the approach that you've taken, this holistic review of both the history and the contemporary jurisprudence. So I'm excited to have it come out and to take a look at it in person. Is there anything else you wanted to talk about the 9th edition of the constitutional law book before we go on to a couple of other topics?
This thing I'd say, it's not so much the book, but I think the moment in time is that in the past, we've had courts, Supreme Courts, that were seen as either more liberal or more conservative, but the individual justices did not tend to vote in a predictable way on some of the most controversial cases. based upon perspectives that didn't necessarily follow any traditional legal form of analysis. And I think that's, as a professor of constitutional law, I think that's something that students are going to be very interested in and that we're going to have to be talking about. I don't think we did a lot of that in the book because it's a little early in the process, but it's certainly one of the hot issues of constitutional law at the moment. And it's, you know, it's certainly unprecedented in the 50 years I've been a law professor.
Well, and if I'm correct, all three of you clerked on the court, the Supreme Court, correct?
Correct.
And so how, if at all, does that experience inform your work in reviewing the decisions of the court and how you think this moment may evolve?
Well, if I can build on what I just said, I was a clerk for Justice Brennan in the same term that Roe v. Wade was decided. And one of the things that was both fascinating and illustrative of that time is that the court decided Roe v. Wade 7-2, with 5 of the 6 Republican appointed justices in the majority and 2 of the 3 Democratic appointed justices in the majority. And it was a totally non-ideologically based decision. And the justices were able to work it through themselves in a way that cut right across the political or polarized lines. And I think that teaching Dobbs and Roe at the moment is going to be quite fascinating in terms of seeing not only the change in the law, but the change in the way in which the court is operating as an institution.
So along those lines, I'd just like to follow up because it does touch on your other field, national security and work, Professor Stone. And since all three of you were clerks at the court, and since this year there was the leak of the opinion to a level that we have never seen before in the court, and which I think shook the concerns of all of us in the way that it almost attacks the integrity or does attack the integrity of the third branch and the one that is supposed to be above all reproach. Any thoughts or feedback on what may have prompted the leak, or whether there will be significant changes moving forward so that we can continue to have the utmost belief in the integrity of the court system?
I guess I would just say that, at least to me, the leak was a symptom of an institution in decline, not necessarily the cause or the thing to point to as this is what shows the Supreme Court is teetering on the edge of questioning the limits of the court in a constitutional democracy. Jeff spoke about the oddity, or in some ways the difficulty, of having seen how the court, adjudicated Roe versus Wade and now teaching Dobbs. I clerked on the court when they heard the initial constitutional challenge to the Affordable Care Act. And to my mind, that was also symptomatic of a court teetering toward disaster. And I think that experience kind of led me closer to questioning whether, in the phrasing of your question, we should be giving the court the utmost respect, whether they have earned it. And I think that is part of what makes me excited about teaching constitutional law in a casebook and in a moment that invites people to think about these kind of questions. How should we regard the court? What makes the court worthy of our respect? What happens when it stops behaving, in a respectable, judicious way? And so I think the leak was symptomatic of a larger problem that we have seen over the last decade, if not more, and it's partially a reflection of, as Jeff was saying, the appointment of justices whose jurisprudential views so closely track, the ideological views of the party that appointed them on the major cases. But it's also partially reflective of, as Aziz was saying, the political and social context in which these decisions are being made, where the theory undergirding some of the court's religious liberty cases so nicely channels, these theories that have been propounded by Republican politicians about, the vices plaguing our society. And so, I guess that's kind of my perspective on the leak.
Just to build on that, I think it's a way of seeing the value of a historical perspective to situate the leak of the Dobbs opinion in the wide sweep of the court's development. One of the characteristic features of the court in the antebellum period before the Civil War was the close relationship between many of the justices and elected politicians. For example, the Dred Scott opinion was famously leaked to President Buchanan, and Buchanan engaged in a lobbying campaign of one of the dissenters in that decision to persuade him to change his vote. The interactions over the Dred Scott opinion were not by any stretch unique. I think that by understanding the long sweep of the court's development, by seeing how it has gone from an institution that at its inception was helmed by somebody who had just served in the administration that he was called upon to rule on in the famous case of Marbury v. Madison. I think by seeing that long history of entanglement between the courts and the political branches, we get a perspective on what's happening today, not just in terms of the Dobbs leak, but in terms of the interactions between the justices and other powerful members of the political elite. I'm thinking now of the testimony that Congress heard a couple of weeks ago respecting the alleged leak of the Hobby Lobby opinion. I think we start to understand we both put those news items in perspective, and as teachers and as scholars, we can use them to think harder about the question that I think both Jeff and Leah have rightly raised, which is the normative question that at the end of the day, a student in constitutional law, we hope, asks, which is this the right way to go about vindicating our core values? Is the court doing the task of fundamental law, or is it doing something else? Is it constituted to do that task? And how could that task be done better? We hope that by providing that history, we give both students and professors a platform to ask those questions. And certainly we have, as scholars and as individuals, views about that. But by providing enough contextual material, as you said in the round, our aspiration is that both professors and and students can pose those hard, basic questions for themselves and reach their own answers. And that's really our hope for the book as a whole.
Well, that would be certainly an incredible accomplishment if you can get students to do that and to see it in the court in the fullness of the way you have just described. Well, again, very excited about the Constitutional Law 9th edition that will come out this spring, March is what I understand, 2023. And before we conclude our podcast, I wonder if each of you would like to share one of two things. I ask one question about the evolution of legal education, but we've had such good discussion about our democratic process and our Supreme Court and the integrity of the court, or lack thereof, one might say. I'd like to give you the option of talking about the future evolution of legal education, which I think we are in a moment there as well, where affirmative action and admissions may go away, where the LSAT is going to potentially become optional, where US News is becoming less impactful, at least with the exodus of law schools. So certainly a lot of things changing in legal education. Or if you would like to share what your predictions are initially following these recent court decisions, if you'd like to share what the evolution of the Supreme Court is likely to be in the coming, let's say, 5 years instead of 10? Professor Stone, you want to start?
I guess I would say on both questions briefly. First, I think that at least at the University of Chicago Law School, the nature of legal education has really not changed very much over the years. When I arrived there in 1968 as a first-year law student, the culture was one in which you were never intended to learn answers. You were intended to learn how to think, how to reason, how to argue, how to respond to arguments. And I'm delighted to say that remains the case in terms of the culture at Chicago and of legal education at Chicago to this day. That's one of the things I think that I'm most proud of about our institution. With respect to the court, I mean, I think I would like to have hoped that the very conservative justices on the current court would have taken a deep breath in Dobbs, for example, and done something like what Chief Justice Roberts wanted. I wouldn't have been all that happy with that either, but at least it would have shown a degree of good judgment and responsibility and taken issues over time, which is what they should have done, particularly given the political nature and the polarized nature of the court at this day. The fact that they didn't do that, I think, speaks very poorly of what they're likely to do in the future. They have a very strong sense of what they believe the right answer is, and they're not going to be inclined to moderate that view. So I think that it creates a real problem for our nation, for our legal system, and for legal education.
I would just say two things also to attempt to tackle both questions. One, on the nature of legal education, I very much agree with Jeff and tell my students, you are not here to learn answers. There isn't a singular answer. And if you think that's what you're here to do, right, the exam process is not going to go well for you and you're not kind of getting out of this what you should be. But I also, while I agree with that, I think that some of what we have seen over the last few years with members of the legal profession, including some of the highest members of the legal profession, participate in some of the, democratic backsliding or real more affirmative, explicit attacks on our democracy is kind of testing, the role of lawyers and the responsibility of lawyers in our democracy. And I think there will be questions about the extent to which law schools should be inviting discussions about what is the proper role of lawyers, what is the limit of just taking on a client and making any argument you can, that you can come up with in their service, because the legal profession is a self-regulating profession. And I think that those are questions that have become all the more pressing, again, as we have seen some of the, most highest ranking members of the profession, participate in some of the most troubling attacks on democracy. Second, on the future of the court, the one prediction I would make is just the wildly and quickly changing nature of the Overton window. Jeff mentioned how he would have been less concerned had the court done what the Chief Justice proposed in Roe versus Wade. I think that might be what we will see the court do some version of in Moore versus Harper, the independent state legislature case, where you might not see 5 members of the court embrace the most maximalist version of the theory under which no other state office can make any decision regarding the conduct of federal congressional elections, but instead suggest that there is a role for federal courts, including the Supreme Court, to play in truly off-the-wall cases where state courts are departing from norms of judicial decision-making, but without exactly specifying what that case looks like, but reserving the possibility later down the road of pretty heavily policing how state courts might be protecting voting rights under state constitutions. And so that's kind of the general trend, I would say, is it is going to be difficult to convey to people how much is changing and how quickly, if, let's say, the court doesn't do what it did in Dobbs, which is go pedal to the metal all the way as fast as it can, but nonetheless is significantly and substantially changing, our law and our governmental structure in the process.
earlier today, the January 6th Select Committee presented its final report. And one of the things that struck me when listening to its presentation is two figures who are graduates of the law school I teach at loom large in that presentation. John Eastman, who has been referred for criminal indictment because of his role in sponsoring and advancing fraudulent theories under which former President Trump could have thwarted the lawful counting of the November 2020 vote, and Pat Cipollone, the White House counsel, who was instrumental in preventing many of those theories being adopted by the former president. Both Eastman and Cipollone, are graduates, as I said, of the University of Chicago Law School. They did very different things in the moment of crisis. And I probably not a surprise that I disagree with both of them on many things. But I think a hard task of legal education, one that we hope our book provides at least a platform for professors to work on, is helping students think through the ethical and the political dimensions of what I think are legal questions that don't have answers solely based upon legal materials. I think that Eastman and Cipollone came to the same legal materials, came to the same questions, and did radically different things because of the different ways they had been formed, whether by law school or earlier. And what I would hope is that we could provide in our book a way for professors to guide people, and surely we can't. We get to students too late to really influence them. To guide people toward the right way of making those decisions, the honest and the ethical way of making those decisions, in light of our history, our traditions, and our practices. I think that requires an understanding of that history, an understanding of those traditions, and a sense of what it means to lawyer skillfully within their context. And I think that the question about the court is fruitfully thought of in that context. One of the criticisms of the court's First Amendment jurisprudence, in particular a case called Kennedy, is that the majority opinion bases its ruling upon a set of facts that are demonstrably false. And this is something that the dissent points out. And I think that although that case presents clearly a challenge for professors to teach, it also presents an opportunity. It also presents a chance to think about what it means to be a minimally ethical and competent lawyer. And I think that the court, if it continues to present opinion scenarios in which that kind of challenge is presented, it offers a kind of different ground for training, certainly a more challenging ground, but no less important a ground for helping to form and direct, as best we can, young lawyers in the right direction.
Well, this has been an extraordinary conversation, and I thank you for sharing your thoughts and giving not only a description of the revised edition forthcoming, but also your views of the court and the direction that it's headed. Really appreciate your being on the podcast, and I envy your students. I think you are exceptional professors if our conversation is any indication. And for those who are interested in adopting or reviewing the Constitutional Law 9th edition, that includes Professors Stone, Litman, and Huq as co-authors, then they can find out how to order a complimentary copy or the book at aspenpublishing.com. And thank you again for being guests.
Thank you for having us.
Thanks so much.